Alright, welcome to Topic 5 Membership Rights and Meetings, Part 2 for Company Law in Papua New Guinea Unit. Our discussion will circle with this content. We have insider trading, related party transactions, payment of loss of office, contracting out of liability, insolvent trading, and compensation to the company. Some of the discussions will refer to the Corporations Act of Australia, which will be useful in our discussion also in Companies Act. Now, with regards to insider trading, this is pertaining to persons with authority, such as director or officers, who obtained confidential information and had used those information for their benefit. So, in this case, if the company suffered a loss, then the company can sue those officers who had used those information at their or at the officer's advantage. Related party transactions are transactions incurred between related companies in the case of parent subsidiary, or between company and officers, so company or directors, or company and senior management. Now, as a rule, if the loan is fair to the company, that loan can be approved by the board. Of course, if it is not, then the board should not approve the loan. In general, a director who is not entitled to payment for loss of office unless particulars of such payment have been disclosed to and approved by a general meeting of the company. So, which means the director, if they had been removed and incurred some loss, it's not automatic that the company will pay for it, not unless it is approved by the company under the general meeting. Now, if the company is contracting out of liability, which means they don't have enough assets to cover for liability, the liability will not exempt the director or the employee if they incur this liability as a director or employee. In certain recent development, in section 344, it gives a liquidator in certain circumstances a right of action against a director and certain other officers. Now, insolvent trading, as defined under Corporations Act of Australia, it says here that if a company is insolvent and a director allows the company to incur a new debt, then the director can be personally liable for the new debts incurred. Of course, it is unfair for those who had provided loans to the company where the company, or let us say the company asking for a loan or obtain the loan, is insolvent, and the directors actually allowed the company to incur those new loans. In that case, the corporate veil will not be able to protect the directors, and the directors can be personally liable for payment of that debt. Directors has a statutory duty to prevent insolvent trading because they obviously know more information about the status of the company's financial position. So in that case, if they cannot prevent insolvent trading and then they allow and approve obtaining a loan, then they will be personally liable. Compensation to the company. A liquidator may recover from a director compensation for any loss suffered by a creditor where the director has breached Section 348. The same also applies to the holding company of the subsidiary to pay compensation. So it's straightforward. If the company is insolvent and the director allowed for new loan or debt, and the creditor had suffered a loss, then the liquidator may recover any unpaid dues from a director. Again, if they allow this to happen. Actions by a creditor may only with the written consent of the liquidator bring proceeding against the director. A creditor may take action to obtain compensation without the liquidator's consent with the leave of the court. Defenses. There are no express defenses provided, but it is anticipated that any defense would be based on Section 348 and 349, that a reasonable person would believe that at the time of incurring the debt, there was reasonable grounds to believe that the company was solvent. If they can prove during the time that they obtain a loan that the company is solvent, then they will be able to defend themselves against rights of the or against the actions to be made by the creditors. Now, what are the shareholders' remedies? Here are the types of remedies according to the underlying law. Okay, the first one is the personal action, where the personal rights of the shareholder are interfered with. This would include actions against the company where the company refused to record the shareholders' vote at a meeting, or where the company declared dividend but then they refused to pay the shareholder. So, in our previous discussion, we discussed about the rights attached with the shares. If those rights had been limited or had been rejected by the company, then the shareholder can perform what we call personal action against the company. The second type is what we call representative action. A representative action would be available where one member sued on behalf of all others who have suffered the same wrong. So in this case, one member can sue the company, okay, in behalf of all others who had incurred losses or had incurred that same loss. And then last one, a derivative action. In this situation, the wrong is done to the company. An individual shareholder sues on behalf of the company because wrongdoers are in control of the company and are preventing it from suing its own name. So in this case, instead of a person representing other shareholders, here the shareholder will represent the company. In situations where officers are the one doing it wrong, of course the officers is in position and some may not be in the right position or in the better position to do or sue the officers. So it is better for the owner to sue the officers in behalf of the company. Foss versus Harbottle case law states that in order to redress a wrong done to the company, the action should prima facie be brought by the company itself. If the action complained of is something which in substance the majority of the company are entitled to do, or if something has been done irregularly which the majority of the company are entitled to do regularly, or something is done illegally which the majority of the company are entitled to do legally, there can be no use of having litigation about it. The ultimate end of which is only that a meeting has been called and then ultimately the majority gets its wishes. The rule in Foss vs. Harbottle therefore prevents fruitless litigation where the majority can overturn the court decision by a simple majority vote. If the majority could do this in all situations, it would mean that majority who are wrongdoers will be able to run the company for their own purposes. However, there are certain breaches of directors' duties or wrongs done by the company that cannot be ratified, or in respect of which directors can be released from a personal liability. The ratification must be done in the same manner in which the power may be exercised. And that ends our discussion on topic 5, Company Law of Papua New Guinea Unit. Thank you.